I've been the attorney for Mr. Horner, the appellee, throughout the trial in this matter, and I replaced his prior counsel, Judge Hall, once he took the bench. Other than that, that's the only attorneys Mr. Horner has had. I had the benefit of doing the trial in this matter, and I want to clarify a couple of appellant statements that were made earlier. First of all, appellant never successfully moved for a new trial. Appellant didn't timely file his motion for a new trial, and that was denied by the court. The only additions to the finding by the court in the decree were as a result of the motion to alter or amend filed by the appellee. Second of all, I do agree with one statement of the appellant, in that there is conflicting evidence throughout this case. I think the appellant would like to argue this case on a record that he wished existed, but that does not. The record that exists before the trial court, which as this court knows is the record that is limited to this court, doesn't support the appellant's arguments. There were considerable gifts by my client's father to the family, to Mrs. Horner, to the children. The corporation paid for lots of things for the family. And when the marriage was falling apart, Walt Horner, who my client has no control over, decided he wasn't going to pay for those things anymore. It was his right. They weren't employment benefits for Mr. Horner. Those were generosity of his father, Walt Horner.
Was there evidence, though, that there had been some sort of a contract at some point for these benefits?
I don't think there was evidence of a written contract for these benefits. The corporation had provided lots of benefits for the family. Walt Horner decided he was no longer going to provide all those benefits, including health insurance for spouses in the corporation, and that's when Mrs. Horner's health insurance stopped. Mr. Horner, throughout the entire record, it reflects that he was a contract employee or a contractor of the company, that he was never a direct employee of the company. He was a stockholder of the company for a period of time. His father said, I want the stock back. Mr. Horner paid no consideration for the stock. Mr. Horner gave the stock back. It seems that what appellant wants is for this court to, in looking at the brief, this is the best I can come up with, remand this back to Judge Rettelsdorf to show her math. During the course of this proceeding, appellant never requested, pursuant to statute, the court make formal findings of fact and conclusions of law. They certainly had the ability to ask the court to create that record, but they never did.
Can you tell us where the income number that the trial court came up with and the worksheet came from? What evidence it's derived from?
Well, I think that is the evidence of Mr. Horner's income that he testified to at this time, at the time of trial, was limited to the $3,000 twice a month from heavy-duty specialist, which he indicated at that time was his only income.
But she set the gross income at $7,400.
I understand that.
I'm sorry.
I'm working up.
You're getting there.
I'm
Okay.
getting there, Joe.
My apologies.
No offense. But I think she took that into consideration. And then, I mean, and it doesn't say in the decree, I admit that, it doesn't say in the decree, but if she attributed any in-kind benefits to him, that would make up the addition of that. There was no evidence to rebut Mr. Horner's testimony that at the time of trial, his income was limited to the $3,000 he received as a contractor twice a month from heavy-duty specialist. No evidence in the record to rebut that, impute it, indicate that he was less than accurate. There is evidence that this family did quite well for a period of time with the support of my client's father. But as this court knows, the economy diminished. My client testified with nothing to rebut it, that his business had fallen off. He no longer had the clients he previously had, and he was left with one client, a heavy-duty specialist. And he is basically left to the devices of his father as to what his income will be or what he's going to receive. The appellant wants this court to impute not only earning potential, but I guess in-kind benefit potential that Mr. Horner may receive when there's no evidence or no case law that would ever support that this court can do that. I guess I'll leave that argument right where it was.
Counsel, can we talk a little bit about the income again? Just so that I'm clear, was the $3,000 paid every 2 weeks, or was it paid twice a month?
I believe it was twice a month.
All right, thank you.
From heavy-duty specialist to track maintenance technologies, I believe was my client's business at the time of the trial.
Okay.
There is no evidence that Mr. Horner was earning $138,000 a year, which I think is what the appellant was trying to project his earnings to be in 2010 or in 2011 at the time of trial. There was simply no evidence in this record, no tax returns, no bank records, nothing to indicate that he had those earnings at the time of trial. I do have, by way of a concern in this case, in reviewing the appellant's brief, in that what has transpired here in some ways seems to be an appellate free-for-all. In looking at the record that they're representing to this court, the references to extraneous information not contained in the record before this court, I have to say, is a little troubling to me. Anywhere from representations of her attorney's fees from prior attorneys that are not contained in the record, the only affidavit or record of attorney's fees or attorney's fees to Mr. Ortman, to references to the county assessor's statements for this property, going back to 2004, which are not contained in the record, to matters relating to the sale of the home, subsequent to the entry of the decree, which again are not in the record before the court for the purposes of this appeal. They were not in the record before the trial. We have raised on our cross appeal an issue that Mr. Horner had used premarital funds, which the court found to purchase this house. The court set the value of the house, and when you looked at what the mortgage value of the house, or what was owed on the mortgage of the house at the time of trial, what Mr. Horner's premarital interest was, at the time of trial, in the entry of those orders, there was no interest that the appellant had in this property. She would get nothing out of the sale of the property, yet the trial court determines that it will be appellant who determines the sale and how that works.
And you've assigned that as error.
And we assign that as error on
And
our
there's
cross
been a suggestion that the home's been sold, so that issue's moot.
Well, I don't think it's moot, Your Honor. I think,
Do you agree the home's been sold? You don't dispute that?
well, if the court wants me to testify or to argue as to extraneous information not in the record before this court, I can answer that question.
Sure.
The home has been sold. However, that's not a problem for this court to determine. That's a problem, and there is no evidence in this record other than my acknowledgement that the home's been sold. That's a problem for the trial court, and it's a problem for appellant back when this goes back to the trial court regarding that issue. Appellant posted no bond. Appellant proceeded at her own peril in what she did. And that's reflected in the record that there has been no bond posted by the appellant. Throughout the pendency of this proceeding, and I'm not thin-skinned, I can't tell you how many times I've appeared before this court or the Nebraska Court of Appeals. But throughout the record, either counsel or the appellee is referred to in these proceedings as frivolous, harassing, vindictive, threats, uncooperative, conducting legal machinations, conducting vindictive activities, and jiggering math. That's not how I was taught to argue before this court, and those weren't accusations that I ever thought were appropriate, and I still don't think they're appropriate in these proceedings. My client had every right to raise the defenses he raised in this proceeding and had every right to present the cross appeal he did in this proceeding. There is no record of my client ever being sanctioned by the lower court, nor this counsel, and I make that more as commentary